Good morning, everyone. Thank you to both the boardroom and webinar attendees. My name is Bruce Harwood, and I'm one of the two immigration lawyers here at Boughton, along with my colleague Saba, who is presently approaching her seat. Together with our firm's senior tax lawyer, Bill Cooper, and Elizabeth Reid of our employment department, we're going to discuss the potential consequences arising from the implementation of the final phase of the Entry and Exit Initiative of what's commonly known as the Perimeter Security Plan. This is an agreement between Canada and the United States that was executed in February 2011 and is has been phased in stages. And the major significant stage is going to take place on June 30th, 2014. And my colleagues, with their respective areas of expertise, are going to individually discuss immigration, tax, and employment consequences which may arise from this plan. But before we do that, I thought it would be interesting to show you why this is topical, why this is relevant. And so I'm going to refer you to, and I'll pass this out. This is a New York Times article from 1 week ago entitled, "Your Digital Trail Follows You to the Border." And this article refers to a U.S. national by the name of Jake Owen who was seeking to perform at a cafe in Vancouver. When he arrived at the airport, he told CBSA he was not being paid, even though he was, it would appear he had a guitar slung over his shoulder, and that he was doing this, what he said was, the term he used was pro bono. Apparently there was a text on his telephone, though, that said he was being paid. And so immigration ruled right on the spot that he was inadmissible for misrepresentation. But he also needed a work permit. And the fact that he was not being paid missed the point. The term, if you accept the fact that he wasn't being paid, because that doesn't seem to be the real case, the term work is defined under Canadian immigration legislation to include activities for which wages or commission are paid, but it doesn't stop there. It extends to activities for which persons are in direct competition with Canadian citizens or permanent residents. So regardless of the fact that your employee may say at the port of entry, no, I'm not being paid, I'm just coming up for a specific reason, the fact of the matter is they will always be examined for potential for work. So what happened to Mr. Owen? Well, I'm just going to read from this article. "I was in a big interrogation room with steel tables. It was really cold, and this guy is acting like he'd caught me red-handed." Well, he did. He was caught red-handed. "Telling me he could have me barred from Canada forever." Well, slight exaggeration, 2 years. Work violation and misrepresentation, a misrepresentation in particular, they'll exclude you for a period of 2 years, and so you are barred from re-entry without specific permission. "Apparently I got sent back because I supposedly lied to a federal officer. But I really don't understand what happened. We weren't getting paid. There was no money being exchanged in Canada." Well, again, this article is not really focusing on the realities of the situation. And of course, when they approach Canada Border Services Agency for a comment, they're not going to comment on specific cases. There are privacy reasons for it. So you only really get one side of the story. But although this article did not refer to the Perimeter Security Plan, I think it's the first 3 paragraphs that make the point and the point of this presentation. The author, Susan Stellan, said, "Information, money, and jobs flow easily around the world, yet it's getting tougher for travelers to cross some borders. As immigration policies tighten and the security and technology to enforce them increase, travelers can find themselves caught in a web of suspicion that prevents them from visiting some countries. A past arrest or conviction, even a public admission of illegal activity, can be grounds for inadmissibility. So can political activism or the impression that a traveler is visiting on business without obtaining a work visa. While governments have long aspired to be more vigilant about their borders, Databases and the digital tracks people leave have made it easier for agents to investigate and deny entry to some travelers. And what this plan and / initiative will do will make it all that much easier to investigate and deny entry to foreign nationals. But it also will create problems for permanent residents of Canada and the United States, respectively, and potentially for Canadian citizens and U.S. citizens as well. There are two other points I just want to make as a sidebar from this article. One is the distinction between entry for business and entry for work, which Saba will discuss with you. It's very, very important. The other point that was raised was a past arrest or conviction. For my practice in particular, one of the most common things that I see are business persons from the United States with impaired driving convictions. They're treated as misdemeanors in the United States, very often with a simple fine and some probation, but we, under Canadian immigration law, treat impaired convictions as indictable offenses, and you are barred for a period of 5 years after termination of sentence imposed. And termination of sentence, sentence imposed includes periods of probation. So and very often you'll get a 3-year period of probation on a DUI in the state of California. Well, you're barred for 8 years. You have to get a special permit in order to get into Canada. And unfortunately, people find this out the hard way because our officers at CBSA have the ability to examine the NCIC, which is the U.S. Crime Computer Index. So when they ask a person, do you have a criminal record? They already know the answer. So that's something to keep in mind. One other note is that from reading this article, which I'm just going to pass around, it would appear Mr. Owen got a break. He was just sent back to the United States. He could have been arrested, detained, sent to a hearing, and ordered removed for 2 years for the misrepresentation alone. And it doesn't seem as though, all it says in there is that he was sent back to New Jersey. So again, I think it's this type of incident that we want to avoid for all of our employees who are cross-border travelers. So the full name of this program is the Entry and Exit Initiative of the Perimeter Security and Economic Competitiveness Plan. The first phase implemented in September 2012, the final phase June 30th, 2014, and ultimately this is all about increased scrutiny of individuals at ports of entry traveling between the United States and Canada. The background of this entire initiative is set out in this, in the federal government's Economic Action Plan. There is the electronic address in order for you to access it. It's a 17-page document. It goes into great detail about what is going to transpire with this new program. So if we go to the next slide, please. The document was issued February 4th, 2011. And under the terms of this document, and I'm only speaking to the issue of the immigration issues, Canada and U.S. will screen travelers seeking to enter either country, but what they're going to do is identify individuals who seek, and I'm quoting, to enter the perimeter for malafide purposes. That's a fairly broad term. Bad intent? I mean, we'll see what really transpires when this is fully operational. And to prevent persons who have malafide intent from traveling to Canada. Secondly, this program is designed to prevent individuals from assuming different identities between one country and another. And thirdly, this program is set out to identify persons who've committed serious crimes or violated immigration law and enable Canadian and American officials to make informed decisions on visas and admissibility. So what are they going to do? Well, Canada and the United States are going to use a common approach to screening methodologies and programs, which will include pre-travel screening. Now, you probably all are aware that there are already pre-flight inspections at Vancouver, Calgary, and Pearson International Airports, which some of my colleagues and I went through last week when we tried to gain access to Boston without missing our flight through the U.S. pre-flight in Toronto, which didn't go that well, actually. But what I don't see in this document is whether or not, since this agreement is to affect both Canadian and American operations, is whether or not Canadian officers will now be stationed at U.S. airports and try and interdict and screen people before they get on a plane. So that remains to be seen whether we're going to do that, and I'm very curious to find out whether that is actually going to happen. Now, one of the other points that they're going to, one of the other points that's going to arise from this program is there's going to be an exchange of information on watch lists, criminal history records, and immigration violations. But it's important to recognize that this exchange of information isn't simply going to be about Canadian and American citizens. It's going to apply to all foreign nationals. So I'm going to give you an example. Let's say we have an Irish national, and that's not uncommon here because we have a working holiday agreement which allows Irish nationals to work in Canada on open work permits for up to 2 years. Irish national comes in and for one reason or another he violates the terms of his employment agreement or he overstays and he's ordered outside of Canada. He's excluded. He goes back to Ireland. He goes into the U.S. Embassy in Dublin and he applies for a visa to enter the United States. Well, this entire history of his immigration violations in Canada will now be available to the U.S. authorities. So why would a U.S. visa officer in Dublin give a visa to a person who has already violated the immigration laws of another country? So one of the things that I recommend to persons who are retaining foreign nationals is to ask them if they've had any difficulties with immigration violations in the past. You better know it up front before you retain them, or if you have an intent of sending them in and outside of Canada or the United States. So the key points from, if you could just go back one thing for me, Saba. The key points, there's going to be an integrated entry and exit system. And significantly, to date, Canada has not monitored exits from this country. We monitor your entries, and if you need to see how many times you've entered Canada over a period of years, you can actually file an Access to Information Act request, and you can see all those entries. But as of June 30th, you're going to see not only all of your entries, but all of your exits. And it's going to impact Canadian citizens who attempt to remain in the United States without a lawful extension of their standard 6-month entry. It's also going to impact permanent residents of Canada who may be transferred outside of Canada for extended lengths of time and place their ability to maintain their permanent residence in status at risk. And if time permits, we will address that, but I'm not sure we will today. So there are 3 phases to this program. September 30th, 2012, there was an exchange of data on third country nationals, permanent residents of the United States and Canada, at no more than 4 ports of entry. But as of September 30th, 2013, this exchange of data was extended to the same group of individuals at all common land ports of entry. As of June 30th, 2014, the exchange of information will extend to all travelers, including Canadians and Americans, to all common land ports of entry. But it doesn't end there, because with respect to air travel, Canada will now demand that airlines submit passenger manifests on outbound international flights. So the bottom line is that entries and exits of all individuals whether foreign nationals seeking temporary entry for tourism, study, or work, whether it's permanent residents of either Canada and the United States who hold a passport of a third country, as well as citizens of Canada and the United States, will all be subject to greater scrutiny. As I said, I was an officer. To my knowledge, we have never monitored exits. We knew when you came in, but we never knew when you left. And although they can count up all the unexpired or unenforceable deport orders that have been issued by the Canadian government, they don't really have a real sense of how many illegals are living in this country, no matter what they tell you. The U.S. used to use a form called the I-94, which a number of you may be familiar with. And that I-94 was stapled into your passport when you entered the United States. And theoretically, when you left the United States, myself as the Canadian officer or you as the individual took it out of the passport, and what we would do at the end of a working day was walk across the border with a pile of these I-94s, and they would enter that data into their system so they knew they had people who had left. But it was haphazard at best. And there's nothing haphazard about this new system. They're going to know when you entered, when you left. One thing I wanted to raise, I just made a brief reference to it, is this issue of Canadian permanent residence. The rule for, Canadian citizens have an absolute right of entry, and they can go and live abroad and indefinitely. They're not going to lose their ability to return to Canada. They have an absolute right of re-entry, but permanent residents don't. The normal rule is that in a 5-year period, you have to accumulate 730 days of physical residence in order to maintain your status in Canada. Now, there are exemptions to that rule, and one of them is being employed outside of Canada by a Canadian business. But that has been very narrowly construed in a number of decisions by the Immigration Appeal Division and the Federal Court of Canada. And if time permits, we will discuss in some more detail. There is an outline of the topic in the addendum to the written material provided to you. But for the moment, I'm going to turn this matter over to my colleague Saba Naqvi, who's going to discuss the role of NAFTA and the difference between business and work.
Thank you, Bruce. Welcome, everyone. It's my pleasure to speak to you, and not only everyone here, some familiar faces and some new faces, but also those online through as our web audience. Now, with respect to this program that Bruce discussed, I want to focus more onto the reference that he described about the difference between business and work, and how it affects all of us when we're crossing the border in light of these new enforcement and increased scrutiny initiatives. Now, when we're traveling for business or work, although to us it seems, relatively simple, the distinction between the two is extremely critical. And it's important for us to know exactly the definition that we're traveling under so we can explain to the officer at the port of entry clearly what we're doing and hopefully enter with ease. So when we're entering either the U.S. or if a foreign national is entering Canada, the presumption is that if we are traveling for business or pleasure, we're allowed in as long as we can show basic facts, such as we will return to our home country, and we have strong ties to our home country, and we're entering the foreign country for a limited period. So under the business travel rules, when an individual enters a foreign country on behalf of their employer in their home country to engage in business activities, such as business meetings, conferences and trade shows, negotiating contracts, or engaging in sales and marketing on behalf of their employer in their home country, that is generally viewed as business activities. Now it gets a little bit more complicated when the area becomes grayer. Just to give you an example, if I have an employee who I'm sending across the border and I'm a producer of a product in Canada, that individual, so my salesperson, can enter the U.S. to engage in sales negotiations or to negotiate contracts with a prospective buyer in the U.S. So that's a clear definition of a business visitor. Now, when it gets grayer is if I have an affiliate in the United States and my employee is entering to sell a product to a U.S. client, which the same U.S. affiliate could have their employee in the U.S. take care of. So that's kind of where it becomes a little bit more complicated. And a lot of people think that, you know, it's perfectly fine. I'm getting paid by my Canadian employer. It's okay for me to engage in this activity. However, remuneration is not a determining factor. So in the situation when the U.S. Customs and Border Protection Officer assesses this individual, they want to see if they are actually performing hands-on services in the foreign country. So basically the main profit center is in the foreign country, and that individual is performing activities in the foreign country which someone could be hired locally to perform. So in other words, a job is being taken away from a local candidate, and that would be viewed as work. And as Bruce said, remuneration is a factor, but it's not the only factor. So a lot of people think that they can enter to perform a service to an individual in the U.S., and as long as they're not getting paid, that's okay. Or another myth is that if they're getting paid through a bank account in Canada, then that is not considered work and that's okay. But really it's not, because the second that you cross over and you're performing services for which you're getting paid, that would constitute an activity for which a work permit is required. An example of that would be a consultant. You know, there's a lot of consultants that travel back and forth, and they say, okay, well, we have a client in the U.S. We're entering the U.S. because we want to talk to them about their strategy, their plan, but they're paying me in Canada, so isn't that fine? And the answer is no. People will often travel regularly and not have any issues, but it really depends on the officer that you get and the circumstances, and that can change at any time. If you're questioned more extensively than usual, then it can lead to problems. So that's why it's important to understand the difference. Now, if a business category is not one that's applicable and, in fact, a work permit is required, then NAFTA is an extremely efficient treaty which allows for facilitated entry to certain individuals and professionals. So the first category under NAFTA, which I'm sure you're all aware of and you've heard of, is the NAFTA professionals category. In Canada, it's considered exactly that, the NAFTA professionals, and someone gets a work permit. For the U.S., it's considered TN status, which is Treaty National Status. And on the appendix 1603.D1, there are a series of professions listed, as well as what the minimum criteria is for each individual to qualify under that profession. And so if you or your employee falls within the NAFTA professional, then they can apply at the port of entry and get a work permit on the spot. And so that's an excellent category. Now, the second one is intercompany transfers. So when I go back to my example about the individual who was entering the U.S. affiliate's office, that person can qualify for a work permit as an intracompany transfer. And the criteria for that is that individual must have been employed for at least 1 year in the preceding 3 years for the foreign affiliate, or in this case the Canadian company, in either an executive, a managerial, or specialized knowledge capacity. And if that is the case, then that individual can seek admission again at the port of entry for a work permit as an intercompany transfer. And again, it's called an intercompany transferee work permit in Canada, and for the U.S. it's either an L1A, which is for a manager or an executive, or it's an L1B based on specialized knowledge. And there's specific benefits. L1As, for example, can convert to permanent residence and green card status in the U.S., and L1Bs can't. So it's important to assess the criteria and take a look and understand the rules before you decide on which category is best and how to apply. Now, another wonderful exception under NAFTA is the after-sales service provision. So in the case of selling a product to a foreign country, if you're producing a product and if an individual across the border is buying that product, and if your contract for sale includes a provision for after-sales service or warranty situations, like perhaps there will be a warranty that will cover 1 year of service or training or anything involved in the implementation and the use of that product in the States, then as long as it is specifically stated in the original contract of sale, then your employee can travel across the border without a work permit under the after-sales service provision. So that's an excellent provision under NAFTA. Now, if NAFTA does not apply, which often it doesn't, then alternative work authorization will need to be examined, and there's a variety of them, which unfortunately we can't cover today, but it includes special authorizations such as H-1Bs or some other. For Canada, it would be a labor market opinion, and those are more complex and not as facilitative as NAFTA is. So we benefit, I would say, a lot from the NAFTA agreement. Now, just to wrap this up with the topic, it's important to know the category that you're applying under so you can explain clearly to the officer when you're questioned. If you're unsure, then that creates you to be nervous. It causes the officer to question what you're doing, and it just makes everything uncomfortable. So familiarize yourself with the rules. Know the classification which you're seeking admission. Be prepared to clearly describe the purpose of your visit, and be honest. So, if sometimes people get nervous, and if the officer asks, what are you doing, what are you going to be doing in the U.S., they say, oh, I'm entering for vacation. But then the officer will take a look at their laptop, their computer, which they have the ability to do, and the individual will be caught in a lie because they'll have a reminder for a business meeting in, an hour from then. And so that's obviously going to be a problem. It's going to jeopardize their credibility. And although it seems at the time that you just want to get in, for the long term and for your long-term future, or for the long-term future of your employee, it's a lot better that the individual withdraws their admission to enter and comes back with the proper paperwork. And so that goes to the next point, travel with supporting documentation. Give your employee a letter saying that they're clearly employed in Canada, this is their salary, this is their position, they're entering the U.S. for a limited period, here's their return trip ticket, and they're not going to be receiving any remuneration from a U.S. source. And that's going to make it a lot easier. So that way your employee will know what they're doing, as well as the border official will clearly have it in writing, and it will make it a lot smoother. And even I find just if someone has the letter in their pocket, all of a sudden they're a lot more confident, and the entry process is a lot smoother, and they end up not even needing the letter. And also the last point, which is a segue into Bill Cooper's presentation, which is coming up, is be mindful of other areas of law that will affect your client or your employee. Tax issues are critical. Where is an individual employed? Where are they getting paid? What are their obligations? And same with the employment issues that Elizabeth is going to talk about. So everything goes together. Familiarize yourself, be prepared, and happy travels. That's what it will equal. So I'm going to pass it on to Bill.
Thanks, Saba. So this is all really just a big ploy by the U.S. government to make you all pay U.S. taxes. That's, of course, coming from the tax guy. And for those of you online, if you have any questions, just type them into the question box there, and we're kind of keeping an eye on here. And if there's any questions here, by all means, put your hand up and ask. You've got a couple of very knowledgeable people here. Yeah, no, it's okay. It's kind of interesting because I think my take on this is how this all came about is there are 1,000 trucks every day lined up at the border in Windsor, Ontario, wanting to get across the border. And the U.S. said, well, we can expedite things, but here's the deal. We want to draw a big circle around Canada and the U.S., and we want to lock it all down, and we want all the information about everybody. I think that's what really happened here. So part of the condition of doing that is we'll allow this to happen, but we now need to know who's coming and going. Because we know you Canadians are all down there carrying on business in the U.S. and you're cheating the system. And we know, I mean, I had a client come to me and says, well, I'm living in Canada. I moved down to Bahamas, and he was doing this international business, and he apparently had a legal reason for being there because there's liability issues. He's moved back. His significant other is in San Diego. So how does he get down there? Oh, I've got it all figured out. I come up here, I keep a truck at my son's house, and I drive across the border. They don't get me that way because they don't know that I'm coming back, and they don't know how many days I've been down there. Of course, he's down there, 4, 5, 6 months every year. So I think all of that's going to change now. Although I was just at we're an affiliate with an international group of law firms, about 180 firms around the world, and we had a meeting in Boston at the beginning of the month, actually. And I was talking to some of the tax people at the Boston firm, very good. They know what they're doing, and they said, well, the IRS actually isn't that organized. So we'll see. But I suspect they're going to be getting emails from the Homeland Security saying, we got a guy here who's been down there every year for 5 months or whatever. And this is, I think, where the problem's going to really be big time for Canadians, because there's money in this for the Americans. And they don't really like the fact that there's a lot of Canadians doing business in the States without any kind of visas. They're just not properly down there. And now they got a way to catch you. So with this new statute, which now draws a circle around all of Canada and the U.S., great, that's a good thing, except for now we're going to be counting days, and computers are really good at that. And the thing about this is that it's every day. So you go down for 2 hours to do some cross-border shopping, that's a day. So every day you're down there is a day. And it isn't a 6-month test. The test is really a substantial presence test. And you can get into trouble if you're down in the States 122 days every year or more on average. So I'm just going to run through how that works. But, I know people who've got places down in Palm Springs, and they're down there 3-4 months every year, and then they're doing all the extra stuff. So this is where I think we're going to see problems. Whether or not this happens right away, the guys at the Boston firm say it's going to take them a little while to get themselves organized. We'll see. But computers can count this stuff. I mean, once you run over the formula, then you've got a much bigger problem on a tax perspective. So it's not being whether or not you're a resident in the States, it's whether or not you have a substantial presence, and that is calculated basically by this formula, and the fact that you've been down there for 30 days. So if you go down, you have a place down in the States, you go down to Phoenix or wherever it is for some time in the sun, you spend a month in a given year, and then you meet this test, then you're in big trouble. So the formula is basically takes number of days in the U.S. in the current year, a third in the previous year, and 1/6 in the year before that. So essentially, it's not a 183-day test. If you've been down there 122 days every year, 122 or more, you are now subject to basically full-on U.S. reporting. And the good thing about the U.S. is the actual form is not a big deal, but if you don't file it, now you are in a world of pain. And that's kind of what we're trying to warn you about here, is that if they actually start counting up all the days and all the car trips down to Bellingham or whatever it is, and it turns out that you're spending more than 122 days on average in the U.S., you are now basically having to file U.S. tax forms. So you really want to be careful about this one. How quickly they'll implement it, we don't know. As I say, our U.S. affiliate, a bunch of bright guys down there, don't think that they're going to be that good at it, but I don't know that it's worth it, taking a chance, because once you're blacklisted, they can just stop you at the border. So if you got employees who are regularly traveling back and forth, and now they get busted at the border, that's it. I mean, my understanding is they can ban you for a year or even longer time, depending on how long you've sort of been in the States illegally. So I mentioned the fact that any portion of a day, it counts as a full day to our shopping trips. Transit time in the U.S., so if you are going down to Mexico and you stop in L.A., that doesn't count. But the only problem with that is, and things like if you were traveling somewhere, visiting, and you ended up in the hospital, and the intention was really to come home, but now you're down there for a month because you're sick, if you can actually afford to stay in a hospital in the U.S. for a month, good luck on that one. So that would not count, but the only way you get the exclusions or the exceptions is you've got to file a form. Everything in the U.S. requires filing a form. And if you don't file a form, then you're presumed to be a very bad person. That's basically how they approach things. So if you didn't file a form, you didn't include the exclusions, then every single day you're down there will count. So now let's say you've met the substantial presence test. They can, at that point, treat you as if you are a U.S. resident, and notwithstanding that you're a Canadian resident. So what you want to be able to do here is file a form that gets you the closer connection exemption or exception, and that then allows you not to have to comply with their U.S. system. If you don't do that, if you don't file that form, now you're full on into full reporting in the U.S. 1040s and you basically are going to have to rely on the treaty exemption. So the key here is this 8840, and you have to answer a bunch of questions. And what they're trying to determine is, number one, how many days you've spent down there, and what is your connection with Canada versus the U.S. And the connecting factors are obvious. Well, my home is in Vancouver, wherever. Family is up here. My client that I was talking about, significant other is in San Diego. He basically hasn't seen his family in years up here, so he's down there. I think now he's got a problem, because if they start busting him and coming back across the border, they'll know exactly how many days he's been down there. And of course, he doesn't want to file the 8840, because once you start filing these forms with the U.S. government, where they're going with that is they want to know about bank accounts, they want to know about financial information, and this is kind of the beginning of, the U.S. is now going to require me to start filing tax returns. So you can't claim the closer connection exemption or exception if you spend more than 183 days. So once you're in the 183 days, you're into filing a tax return in the U.S. If you have or you apply for a green card, obviously that's an intention that you're going to be staying there. So that is basically not going to get you an exemption either. And the other really big problem here, and I think this is where a lot of Canadians are going to get busted, is, okay, just pretend they don't know. We drive back and forth. We go spend the 3 months in Palm Springs or whatever. They'll never know, but now they will know. And if you don't file a form, now you are in big trouble, because now you have to basically file a full U.S. tax return. So you can't get the closer connection exception. Then you are basically a dual resident, and now you're into the treaty and you're into filing tax returns in the U.S.
So, Bill, you have a question.
Let's see if we can actually see that. Come on.
There you go.
Well, it's a big question. So, okay. An individual with an H-1B visa enters the U.S. with spouse who has visitor's visa. Spouse continues to work for Canadian employer through the internet. Would this violate any U.S. immigration rules? Guys? Is the income earned in the U.S. considered U.S. source income requiring filing a U.S. tax form by the spouse's substantial presence test not met?
Okay.
So he's got a legitimate visa,
yes,
but he's brought spouse along who, of course, needs to make a living,
right.
and she's continuing to work for a Canadian employer on the internet. But presumably this is work that's being done at a Canadian location.
Right.
Which, I mean, I go traveling.
Yeah,
I have my computer.
Exactly. So the spouse is working for the Canadian employer, so she's not subject to U.S. taxes. It's not a violation of any U.S. immigration rules because she's not providing services to a U.S. employer.
Right.
So the spouse is okay with respect to the immigration side as well as the tax.
Yeah, I don't see a problem there.
Right.
And that's the Canadian employers providing services to U.S. companies.
Exactly.
And that's
the other way. It's the same thing the other way around, because they're in Canada and they're working electronically for a U.S.-based employer. They're not competing with Canadian citizens or permanent residents. So, and if you look in the Temporary Foreign Worker Manual published by the Citizenship and Immigration Department, they specifically mention that this is likely an exemption from the work requirements.
I mean, this is obviously, this is the world we live in now. I mean, I got on Hawaii, and I am dealing with my clients up here. In fact, unfortunately, every time I go through the border, like you get a little mark in your passport because there's like, well, how long are you going to stay down here? Well, honestly, I can't practice tax law in the United States. I mean, it is like two different things completely. The second part of the question here is basically the same question for the U.S. individual moving to Canada, and we've had that going on for a long time. So while retaining his employment with the U.S. employer, does the work through the internet, is the income now considered a Canadian source? Yeah, I mean, the difficulty is if you are actually performing services in the other jurisdiction, then you've got a problem. And this we see a lot of. So going both ways, and actually we've got a presentation, I think maybe online, but we've got a lot of U.S. companies send their people up here, they send their techs up here, and basically they're performing jobs that local people could perform, but they've got the expertise. But then if they overstay, and the problem is now you're into the treaty, you are now potentially subject to Canadian tax rules. Yet you have to sort of look at how long they're staying, what they're doing, how much money. I think $10,000 is sort of the limit. And then once you get into that area, you could be, either way, you could actually be a situation where you should be remitting, treating the person as a Canadian employee if they're U.S. up here, or vice versa. and then deducting and withholding. And Elizabeth's going to deal a little bit more with this, but it's a problem. So now we got a further question from the same fellow here. It says, I have a U.S. passport. Okay. I have a U.S. passport, born in the U.S., and a Canadian passport, and file both Canadian and U.S. returns. What will change in my world? I think at that point, you're subject to both regimes, so you're fully reporting now anyway.
Yeah, so you should be fine.
You should be fine, yeah. I think the real problem is going to be, and our concern here was more from, we got Canadian clients who've got employees who are traveling down there on a regular basis, and they're being asked to travel, and then they take their holidays in the States because that's where it's sunny. They got Hawaii, and now suddenly, without even really recognizing it, they're over that 122 days, and they're not filing any forms.
Yeah.
And in the past, nobody is worried about this, but the problem is, as I just mentioned, is if you run over that threshold, and now you don't file the Form 8840, now you're just deemed to be a resident in the U.S., and now you've got to file basically a full-on non-resident tax return in the U.S. So, and that's not going to be a happy event, and I'll explain why. So you
another one.
We'll wait.
I guess we'll have to wait.
Yeah.
Okay. That's not moving.
Oh, maybe if you unclick the question.
Ah. That would probably do it. Thank you. So I think ideally, now you do need to keep track of how many days you're down there. I don't think, certainly we as lawyers can't advise you, oh, don't worry about it, the IRS is incompetent, they won't be able to keep track of this. Bruce, being a former border guy, says I suspect the border guys that we're dealing with in the U.S., they don't like the fact that Canadians are down there carrying on business, not paying any tax, and not being truthful on their entries. So my guess is that sooner or later they're going to start sharing this data with the IRS, and things are going to start to happen. So if you've got to file by June the 15th, this form, and if you have actual employment income down in the U.S., the deadline is April the 15th. There's no provisions for extension. You either do it or you don't do it. And then the other problem is if you've got U.S. source income from any source, dividends from shares in a public company, now you're into the world of penalties here, where you basically you can be liable for a $1,000 penalty for each item that you've failed to disclose. So it's hard to imagine any Canadian who doesn't have, if you've got investments, you probably have some U.S. investments, and you're probably now walked yourself into this problem. So it's important that you pay attention to this and do something about it, and definitely keep track. And I don't think it's going to be a good idea to just ignore it in the future. So it gets even more complicated. So I'm just here to tell you all the bad news. But it's, if they apply these rules the way they're written, this can be a really big problem. I mean, if you're an employer and you send people down to the U.S. on a regular basis, and they're taking holidays down there, and suddenly they're over this magic 122 days a year, bingo bango, and they're not filing the returns, now you have caused your employee to be in a world of pain. So beyond the income tax filings that they haven't done, and if you don't file your tax return, so if you didn't file the form, and then you didn't file a 1040 NR, that's a $10,000 penalty. Everything in the U.S. is a $10,000 penalty. So, I mean, this is serious stuff. On top of that, they have these foreign bank account regulations where they're trying to keep track of all the money that's floating around. And so now if you meet the substantial presence test, never mind the income tax problems, there's the financial reporting problems. So basically, if you've got investment accounts outside of the U.S. with the combined balance of greater than 10,000 bucks, that's not very hard to, and you fail to file the Form 8840, now you're going to have to start filing on all of your bank accounts and financial accounts. I mean, it's kind of crazy. I mean, what does the U.S. really, why should they want to know what's going on up here? But their approach is the moment you fail to file, you are a U.S. resident, even though you're not, and then they want to know. And the problem with being, on the question we had here about having both passports, gee, I'm sorry for you, because you really don't want to have a green card or a U.S. passport, because they track you wherever you go. So now we're into a situation where if you've got investment accounts of greater than $250,000 and you didn't file that Form 8840, and even though you're not really a U.S. resident, $10,000 penalty per account per year for failure to disclose. So this is just getting a bit ugly, and you sort of say, oh, well, they're not going to do that. But they do this. We have dealt with people, you just like, are you kidding me? $10,000 a year? This person didn't even know they were a U.S. person. They didn't know. I got a client whose son was a vice president of the North American Soccer League for 2 years. During the 2 years, one of his sons was born down there. His son has got nothing to do with the U.S. And then they came back in my office one day and they wanted to set up a trust. So, okay, well, wait a second now. I think maybe wasn't he born? And bingo bango. So now we've got a problem. So we can't even do any proper Canadian planning because we've got a U.S. person. We've got somebody who's born there. And this happens all the time. So, and then you get into this situation where now you're looking at, this has got nothing to do with taxes. It's simply to do with their foreign bank account reporting regime, and you didn't report, so $10,000 penalties. And again, these FBARs have to be filed by June 30th, and again, there's no extensions if you didn't file them. So it's just kind of a very onerous regime. People, I think to date, Canadians have just been ignoring this, and how long we'll be able to continue to get away with that, I don't know. The real problem here is that the penalties are just horrendous, and they don't seem to have any problem in imposing these penalties. I've seen situations, you've got grandma who basically is an accidental U.S. citizen and hasn't filed ever, and it's like, well, you want to get up to date, it's $10,000 a year, da-da-da-da, voluntary disclosure, and sorry, we don't care, doesn't really matter, it's not our problem. So that's the good news on the tax side. I think there was one more question here. Okay. So that's my piece, but let's see if we can answer a few questions. So, oh, yeah, here's the guys that we're trying to get across the border. This is why we got all this, because we got all these truckers who want to get across the border at Windsor, thousands of them. The truckers who travel down to the U.S.,
they do not count the days that they in.
The days do not count to do that?
Oh.
I don't see why they wouldn't. It stays in the U.S. Yeah, I mean, you intended to be in the U.S. You're not sick. You're not dying. They're going to count.
2 hours of shopping in Bellingham, so why wouldn't it?
Yeah, I'm not aware of all the provisions here. I have to be honest with you. I haven't sat down and read the whole thing, but I can't see why those would be days in the U.S. So somebody's on the road a lot, they could very easily be across this problem. Can you clarify if you filed Form 8840, you do not have to file, that's correct, the 1040. So if you file the 8840, you're not a resident in the U.S., you're only caught because of this 122-day sort of average rule over the 3 years. If you file the 8840, that's the end of it. So that's why it's important to file that form and not stick your head in the sand. And that is true. Thank you very much. So if you've got dividends or rental income, you got a place down in Palm Springs, you're renting it out. If you've got any income in the U.S. at all, you have to file the 1040.
And you file the 1040 NR with the 8840, then it's attached to the 1040.
Right. Yep. 100%. That's my understanding as well. So yeah, and it doesn't take much to have U.S. source income. So again, at this point, we haven't seen a lot of enforcement of this, but now that the tools are going to be there, I mean, Bruce, you covered this earlier. I mean, I just don't know how far they're going to go, but it's a bit scary to just be taking a chance on this now because of the penalties here. And as I say, I mean, our experience is that they show no mercy. It doesn't matter whether it's grandma or it's the kid who was innocently born in the U.S. on a trip. It doesn't seem to matter. It's just penalties, penalties.
Just a follow-up question. Is any immigration data ever shared or could be shared with the U.S. states?
The individual states?
Yes.
I mean, these treaties are between the nations.
But this is obviously the U.S. immigration would have all this information.
Yeah.
So could California. My concern on that person that they're supposed to 5 months, they're sitting in California, they just suddenly subjected my corporation to California income tax.
Yeah.
The compliance costs would be
enormous. Yes.
like literally be a case of they want to fire this person because they can't afford to pay $1 million+ costs to figure out my tax limit.
Yeah.
I'm more concerned with state income tax.
And California doesn't follow the treaty.
Most,
They don't recognize the treaty.
most states don't, but California progressively doesn't, New York doesn't, quite a few other ones don't.
And my understanding, and we had a situation recently in our, we had a guy out of the oil patch who's got loads of money. He's down there all the time, and somehow got caught in California. Not sure exactly how this came about, but I don't think there was any sharing of information. He applied for something, and they said, well, how long are you down here? Well, I have a house. Well, well, I'm only down here like 2 months of the year, which he was. But, well, you got a car here, yeah, and you got a cell phone here, yeah, and you got a bank account here, yeah. You're a resident of California. Here's the tax bill. So, and the guy was, by any other test at the federal level under the treaty would not have been resident.
For taxation, California has an extremely low threshold for
Yeah.
taxation purposes, so it doesn't take many days to be in California. It's extremely low.
I think if you just
I'm concerned with the company side because honestly, the employee is to some degree on his own.
Right.
I don't want my company.
Yeah, and so now you've got somebody who's now considered a. Yeah. Question down here?
Yeah, question, how costly, how difficult is it to file
It's a pretty simple form. Yeah, sorry. The question was how costly or difficult is it to file the 8840, and I don't do them, but yeah.
It's quite easy. It's a two-pager.
Yeah.
Again, hopefully most of those questions are planned to answer literally just Canada. I mean, I do a very large amount of these, and it's quite simple. I mean, I typically want to give some advice to clients just to make sure that they're answering the questions as truthfully as possible, but it's quite a simple form. And it's just a two-pager that you would just, again, assuming that you don't otherwise have a reason to file in that, the two-pager, and you just send it off. You don't even need an ITIN, taxpayer identification, and just file it.
So somebody is responding here just to those of you online, and that's my understanding as well. So it's a two-page form. It's pretty simple to file. And this is the crazy thing, because if you don't file it, you're into full-on regime. But if you file it, you're okay, no penalties. So, I mean, a lot of people just ignored this. I mean, the client I was telling you about who drives his truck across the border, he said, well, you should file a Form 8840. He says, I don't want them to know who I am or where I am. So
the only risk that we find is that with people who want to try and start filing currently and going forward, the problem that I've seen is that they ask for all 3 years, and your date counts for all 3 years. You have to disclose that on the form. So if it's pretty obvious that in the prior year, so if you were going to file a 2013 form, 8840, and you disclosed that you had significant days in 2012 and 2011, they can tell you've already breached. You've breached in a prior year. Hopefully you didn't exceed the 180 days.
Right.
Never mind the fact that you could have also exceeded. You haven't really meant it, but you haven't really exceeded the 180 days, which is more of an immigration issue, which is in a rolling 12-month period versus 183, which is in a calendar year typically. So, they have the information available. So, there's this sort of quandary that clients are going to find themselves in if they just currently file the forms, and they have that information to see that you probably have the filing requirement in the prior year.
And that is the problem as well, because once you find somebody, so they start asking the questions, and then you get over 180 days. Now, as you say, you've got an immigration problem. Now you can be barred from the U.S. for a year or longer.
You don't file anything, and 6 months from now or a year from now, you get sort of a very innocuous letter about, hey, Mr. Crosby was liquor a lot. Tell us about that.
Yeah, and again, it's kind of the comment that Saba made is like it's better to be honest with these guys, because once you get caught in a lie, you just have a black mark, and it's big trouble. So
it's better to be honest on the 88 and 40 as well.
Bank
accounts, disclose them. If you have a rental property, if you have vacation property down there.
Yeah, and I think for some people this is the problem, because this particular guy he's a very large Swiss account. So and not that he was in the U.S., but so the concern now is, well, what are they going to start asking about that? And as we've all heard, I mean, the U.S. has just gone nuts on people who've got offshore accounts. So I mean, and we don't really know. You can't really tell people, well, you can file this information. What are they going to do with it? Not really sure. So it's a problem, and it's a problem for companies too, as you say. I mean, it's a good concern. So now you've got somebody down there, and they're considered to basically give you a presence in the U.S. And now I haven't really dealt with any of that, which is the whole idea of the corporate entity is now got somebody in the U.S. that's got authority to do contracts. So now you basically are in the U.S. Your company's in the U.S. You've got filing in the U.S. and in the state that you're in. And the costs, and people don't realize it. It's, oh, yeah, it's way cheaper in the States. You have no idea. Everything is 5 times more expensive in the States. All the tax filings, it is an expensive place to do business, especially California.
This is on for corporate federal tax purposes. It's actually not bad. It's when you go to the States where they have a doing business test, which is California, New York are probably two alternative. You breathe in the state and they won't want you to pay tax. It's not quite that bad, but it's pretty close.
Low threshold.
They're perfect.
And do remember that it's not the old days where you handed the person your passport, they ask you a few questions. The standard questions are, what's your citizenship? I know they don't say these things. They say, where are you from? Well, that's not really what they're supposed to say. What they're supposed to say is, what's your citizenship? What's the purpose of your trip? How long do you intend to remain in either Canada or the United States? But now they're swiping your passport on a glass panel, and that information is key. It's going to come right up on the screen, and your history is right there. So they know exactly where you've been and what you've been doing, because in terms of entries and exits, because the days of stamping passports have been, at least from a Canadian perspective, have been over since 2012. Now they rely on the electronic provisions, and the problem there is really for one of the big problems is for permanent residents who have to renew their permanent resident card, and they have to account for all of their absences from Canada. And it's also a problem for persons seeking Canadian citizenship, because there's a residence test, and again, they have to account for all their absences from Canada. And then it used to be a rather haphazard approach of reconstructing stamps. Well, now it'll be a lot easier for them to verify if you've really been here, if you really meet the physical presence test for renewing permanent residence and the less onerous test of residence for citizenship, because they'll be able to just simply print out the entries and exits and calculate.
I just ask for, on that basis, June 30th, 2014 when that information, or the question is it June 30th, 2014 going forward, or is it based on information based on historical years?
No, I think it's been rolling over. Where I've really noticed it is in the number of inquiries we've had from employees in the United States who, I've got to come up and give a conference in Toronto in 3 months, and I've got this conviction, and someone told me I'm going to have trouble at the port of entry. Yes, you are going to have trouble at the port of entry. Do they have the discretion to admit you? Yes, they do. They can issue the permit right at the port of entry. But I'm not going to advise anyone to apply at port of entry to do that, because they may just turn you right there, turn you back and say, go to our consulate. And unfortunately, on the West Coast, the only consulate that's left that deals with immigration issues is the consulate in Los Angeles, and it can take you 6 months to get one of those permits.
So it's a bit of a real problem. And as I said, they know that there's a conviction, right? Some charges, even if they haven't been administered in the U.S., will still bar you because our law talks about acts, not just convictions, criminal acts. So you have to assume that that you have to go. First of all, you have to answer the questions honestly. Even there's at the bottom of the.
Why don't you just say?
Oh, the audience can't hear me.
Yeah.
Just
Sorry.
come up there and say what you were wrap up what you were saying.
All right. So all right. So just in summary, you have to assume that the border officials on both sides of the border, Canadians and Americans, CBSA, U.S. Customs and Border Protection, know your history, know the amounts of times you've been in the United States, and if you've been a frequent traveler, yes, you're going to be asked, and you may get a free pass in for a secondary examination. You won't just pass the booth and keep going. They'll send you in. So you have to answer truthfully. As there's a lawyer quoted in that New York Times article that says, answer the questions truthfully. You can assume they know what they're doing and what they're talking about. And yes, they don't apply the law consistently at the border. And yes, particularly from the Canadian side, that's where officers start. That's where they get their training, and that's where they normally start before they get to move to promotions and inland. So they don't know all the NAFTA rules. And they don't know all the rules on exemptions from work permits. And you have to be very clear when you go there and be documented, as Saba pointed out. Be documented when you go down there. If you're sending someone down to the United States on business, have a letter that they can just pull out and say, this is who we are, and we meet the criteria for business. We're not here working. Sorry.
And no, that is good. I mean, unfortunately, and apologies to the online listeners, we don't have mics around the table, and there's some good discussion here. We tried to sort of capture all of that, but there's a couple more questions here, and then I'm going to turn it over to Elizabeth. But so further to my previous question, is the spouse working through the spouse is working through the internet not required to file a tax return if substantial presence not met? So I mean, this will really depend on where they're doing the work, and I have to tell you, I mean, basically, nobody has figured out where business is being conducted if it's being conducted on the internet. This is a big open question, but safe to say, I mean, if the work you're doing for a Canadian employer involves people somewhere in the States, you may well have a problem. You may well should be reporting in the U.S. I mean, it's very fact-driven, so it's hard to give an answer to that. But I mean, if you're, for example, I'm down in Hawaii, I'm working on a file, it's all Canadian-related. I mean, I'm on the internet because that's the way you get access to the information. I'm not working in the U.S. I'm not taking work away from somebody in the U.S. I don't see that being a problem. But if you are down negotiating contracts on behalf of a company, Canadian company, in the U.S., that's a whole different problem, because now you are subject to, under the treaty, to U.S. taxation. So, and then the question was, which country has the first right to tax the income? Now you have to go to the treaty. I mean, if you do have a presence in the U.S. and you're conducting business there, now you've got to look at the treaty to see where you end up with that. And it's a little difficult to answer without all the facts. Is it possible to ask the border guards how many days I've been over the border this current year? I have Nexus, so I'm sure they have it registered. My understanding is part of this process now, you are going to be able to, there's a form you can file and get the actual number of days.
File an Access to Information Act request for $5 to CBSA, and they will print out all of your entries, and I assume after June 30th, exits. Now, Saba can address the American side.
Yeah, I mean, I think that, as Bruce suggested, you should really file a Freedom of Information Act, preferably on the Canadian side, because you're likely to get information a lot faster. Also, with respect to asking a border officer, we never know who we're going to get, so I would not really ask them anything other than respond to the questions that they're asked, that they ask you. And I think that, let's see.
The question on PR card renewal.
Okay. Okay. So that, yeah, so with respect to the Nexus question, I think it's really important to just keep track of everything, all of the travel that you engage in, and yeah, you should be able to go through the formal process rather than ask the order. Now, for the PR renewal question, the question is, would you be able to argue that the 2-hour shopping trip counted as a day in the U.S. should also count as a day in Canada, since you are sleeping in Canada? I would argue yes, and I mean, I think that the technical definition should allow you to count that as a day in Canada as well. Citizenship and Immigration Canada on the forms generally likes to see you leave one day out, either the day in or the day out, as not counting. But if you're really tight and if you're really on the line, then I would count both days as a day in Canada. Right, Bruce?
Yeah, you will see policy guidelines and the Citizenship Manual basically use the Federal Interpretation Act and say you don't count the first day, you count the last. But immigration, when counting days for recovery of your a new permanent resident card, and you have to count your days, policy says any time of the day spent in Canada counts as a day. So that person is going to be fine.
Yes. So yes, count both days. Yeah. I would say.
Yeah.
Okay.
Thanks for those questions. And that's all I have. Over to Elizabeth. And I don't know if it was mentioned, but Saba is also, you're called
in Canada and the States.
In California? Or?
Yeah, California. Yeah. Okay, thanks everyone.
I'll have to look at it.
Oh yeah. Questions.
Got to the end of all the questions.
We're just dealing, for the webinar audience, we're just dealing with a couple of technical issues with the questions here, but I think we're ready to get started. So my name is Elizabeth Reid. I head up our employment, human rights, and labor practice here at Boughton, and I'm here to talk to you in about 12 to 15 minutes about managing the global employment relationship. As you can guess by the fact that we're talking about 12 to 15 minutes, this is going to be pretty high level. And it will basically say, here's where the alligators are, come see us, and we can figure out, exactly where they are and what they are and how that's going to affect your business. So as you've heard from my colleagues on the immigration front and the tax front, anytime you have work performed in multiple jurisdictions, you're going to run into a whole bunch of issues. And I'm going to clarify that when I talk about work, I'm not using it in the very specific way that my colleagues do in terms of, a specific definition of work under the immigration law or a specific definition of work under income tax rules. And of course, that just highlights your first challenge, is that different considerations come into play whenever you're dealing with these different bodies of law. And so you can have someone who might be an employee performing work for employment standards purposes, who may not be an employee performing work for immigration purposes, and who may not be an employee performing work for income tax purposes. Of course, in the immigration context, we're looking at perimeter security and job security for nationals. In the tax, as you heard Bill say, it's all about the money, how much can we get? And from the employment perspective, it's usually about protecting employees from unscrupulous employers and getting the tax money, because you want to deduct things at source. So essentially, both sides in any kind of cross-border employment relationship want to be really clear on a couple of basic things. And we're not talking about the pay and the terms and what are they going to do, those kinds of things. We're thinking specifically for this talk about the kinds of issues that arise from that cross-border aspect. So you want to look at the nature of the travel that's required. You want a clear understanding of how much travel are we expecting this person to do. Is relocation to another jurisdiction going to be required at some point in their career? You want to know about the employee's ability to undertake that travel, what law is going to apply to the employment contract, and if there is a dispute about that contract, where are we going to go to solve that dispute? And I'm talking specifically about employees who are proper employees. Independent consultants, of course, are their own kind of pickle. They're really uncomplicated from the employment standpoint, as long as they really are truly independent consultants, but they still have issues with immigration and tax as well. So the first thing I recommend is start at the very beginning by weeding out the people who can't travel. If you really want to do cross-border business and you want to be sending people back and forth, then you can make it really clear right from the beginning with your job postings, this position requires international travel. Let people who know that they're criminally inadmissible either figure that out before they apply or self-select out so that you don't have to deal with it. You can even say on your applications, you can say things like, this requires international travel. Applicants should have or be able to obtain before starting, a valid passport. You can start to kind of manage these things right from the very beginning. And the other thing I want to be really clear about is when you're looking at posting positions that might be cross-border, think in advance about which company, particularly if you have a corporate group, think about which company is the best company to be the employer, and put that in the job posting as well. So there's never any confusion about who is this person actually going to be employed by. Is it, Petro-Canada? Is it Petro-Canada doing business in Hong Kong through an affiliate or a subsidiary? You want to sort that out before you even get people hired. Okay, so you've got the job posted. You've allowed people to kind of self-select out if they know they wouldn't be able to travel. First thing you want to do is get your employment contract in place. Now, I'm assuming that you are all already convinced of the importance of an employment contract. If you're not, just come talk to me afterwards. I will convince you on that one. You will pay me a lot less money up front than you will if you don't have one and then you run into problems later. So for this point, we're just going to highlight some of the key things to think about with your employment contracts in addition to the kind of usual things that you'd put in. So the first one is specify the employer. I'm going to go into a little more detail about each of these points. The second is look at what representations and warranties you're asking for from your employee. You can use those to kind of flush things out before you get into your employment relationship. Think about what law you want to have govern this contract, and then think about where you want to dispute the contract if there's a problem. So the first point, specify the employer. And the reason I'm kind of harping on this one a little bit is that in the absence of any specified employer, if there's any connection to, for example, British Columbia, there's a common employer doctrine under both our Employment Standards Act and under the common law that can put all of the companies in a corporate group at risk, even if those companies are in other jurisdictions, if they're doing other things, if they've not had a lot of connection to this employee. So you want to be really careful about that. And so what is this common employer doctrine? Well, it's a legal principle that was designed to effectively prevent unscrupulous employees from avoiding their obligations under employment standards legislation and under employment sort of law generally by creating complicated corporate structures to kind of insulate themselves from liability. And so the usual rule, of course, is if you've got companies in a corporate group, I mean, that's exactly why we do have different companies, so that we can insulate them from liability. And under the usual rule, those companies are all separate people, and so you don't have to worry that the debts of one are going to be sort of visited on one of the other companies. Now, the common employer doctrine just turns that right on its head. And it basically says, we don't care. We're going to ignore all that. You guys are all one big, huge megacorp. You're all going to be together, and we're going to get the money for this employee from any one of you. And yeah, and they basically just take the whole concept of separate legal personality and throw it right out the window. And they are very keen on employing this particular doctrine because, unfortunately, most of the claims that come to the Employment Standards Branch, they're used to dealing with certainly some people that are not in compliance and have done sometimes grievous things to their employees. But as a result, of course, multiple companies can then become the employer. So even though the employee might think they only have one employer, when they get to the Employment Standards Branch, they say, oh, well, you know what, this is great. It doesn't matter that that company is bankrupt or you can't get anything from them. It's related to these other companies. We're going to lump them all together. Now, there are a few subtleties to it, but that's kind of the basic principle. So as a result, the more you can specify the employer, the more you can minimize that risk to your other corporate entities. So think about when you're hiring someone who's going to be doing some cross-border work, who do you want to be the employer? Why do you want that particular company to be the employer? And then, to the greatest extent possible, try to be consistent. So try to run the payroll through that company that's the employer, make the employment contract with that same company, and make the reporting relationships in that company if that's possible. Just try to focus it all on the one, and then you can minimize the risk to the other members of that corporate group. And that includes looking at secondment agreements. If you need to send someone on kind of a lengthy visit somewhere to another one of your subs or an affiliated company, put in place a formal secondment agreement that says, okay, we are just loaning this person. You are this Canadian entity or whichever entity you've decided is the employer is still the employer. You're just kind of on loaner. And if you document things, the more clearly you document things, it's very similar to the sort of immigration and tax perspective. The easier it is to then prove that this is what we legitimately set up, and you can kind of go forth honestly, and they don't have to start, fishing around in everything else. Use formal transfer agreements if you are going to transfer someone permanently to one of your other locations. Now, how do you decide what company you want to use to kind of be the primary employer? You want to look at, of course, where is the company operating that they're going to be involved with? Where's the employee usually resident? Where are the services being performed? Which company is going to pay for the services? All of those factors kind of come into play in deciding which company is going to be the best one to kind of focus on for this employment relationship. So once you've decided that, get those reps and warranties. Don't bring this employee on until you have a signed contract in place that deals with things like, that specifies that international travel is required. It is a job condition that you be able to travel internationally. Make the employment conditional on getting all of the approvals and visas and permits that my colleagues have talked about. Flush out those Irish nationals that Bruce was talking about. Sometimes just by putting the reps and warranties in the contract, that will make the employee start thinking about things and go, oh, wait a minute, okay, they're really serious about this. I better think about, are there any reasons that I might not be able to come to Canada? Have I had any immigration problems in the past? So it can help sort of flush out those issues. So at least if you do decide to hire this person, you already know you're not going to get that 3 a.m. call from the border 6 months after you hired them going, I'm stuck, I can't get across to this meeting, or I'm going to miss this big sales conference, I can't make the pitch. Address the tax issues. It may be as simple as saying, employee, you're on your own from a tax perspective. If you're the employer, that may or may not work, but certainly at least for their personal tax, you may want an indemnity from them that if the employer, if they screw something up and you end up on the hook for it, you may be looking to them to recoup the losses that you've suffered as a company. And make sure you provide for a specific governing law and forum. So to the extent you're able to, you probably want to choose the law that's going to apply to your contract. So here's my little test. This is our case study. So which law is going to govern this situation? I'm looking for audience and webinar participation as they desire. Your head office is in Russia. You have a large corporate group. It includes a Russian company based in Russia and a Hong Kong company which is licensed to do business in Texas in the States. There's an operations office in Texas. You hire a Russian citizen to perform work for you in Moscow. He lives in Moscow. He's based in Moscow. He does all his work there. But the contract that you entered into him is run through a little company that he set up for who knows what reason, but this is how it shook down. This is an actual case. He had a VC incorporated company that he was the sole director, officer, and shareholder of. And that VC company had a VC bank account. And so the money for that contract, notwithstanding that everything else happened in Moscow, the money ran through the VC bank account. Now, any thoughts on which jurisdiction this ended up in, or who wanted to take jurisdiction over this case when there was a dispute over the employment contract? Thoughts? Hands up. Webinar people, you can weigh in on the entered questions thing if you want.
What was the employment issue to begin with? It sounds like he's like one company contract another company. Like there doesn't seem to be an employment relationship there to begin with.
Right, that's an excellent question. In this particular case, he was, just because you have a corporate entity there doesn't mean necessarily that they're not an employee. So you can have an independent contractor, or someone who you would think is an independent contractor, who might be running their relationship through their own company, but that person can still be an employee for employment standards and sort of common law legal purposes. Unfortunately, the determining factor is not just what it says in the contract or how the contract's run. There's a whole series of tests about who has control over the tools, you know, et cetera, whose business is it, and ultimately this, in this particular circumstance, it ended up they were looking at an employment relationship.
I think BC law is going to govern. I certainly think Canadian law will govern from a tax perspective. I think the Canadian company who is starting to the Canadian company, it sounds like they're running it through the BC company, right? They're paying it into the BC company bank account.
And that was the decision that they ended up going with. Madam Justice Holmes from our BC Supreme Court decided that there was a real and substantial connection to British Columbia in this case, even though he didn't do any work here, he didn't live here. All that happened was the money flowed through a BC bank account that was in the name of a BC company, and that was it. So that's a fairly tenuous, in this particular circumstances, connection, but it was significant enough to allow the court to take jurisdiction. So just a little point on choice of law versus choice of forum. So choice of law, you can choose the law, at least to some extent, that governs your contract. But the law that you choose might not be the only law that governs that contract. So to give you an example, you know, you can say this is going to be a state of California contract. But if you have an employee who's, even if it says it's a California contract, but the employee is performing services or doing work up here in BC, and this can kind of come up if you have a home office, you know, or you're just up here for a while. As long as if you have some kind of work being done in British Columbia, there are mandatory employment standards laws that are based on territoriality that could also apply to that contract. So you've always got to be a bit careful about where is everything happening so that you can try to figure out what laws potentially might apply. And the factors, of course, that they'll look at are things like where's the company located, where's the head office, who are people reporting to, where's the person, you know, physically sitting and doing work, and, you know, the same kinds of issues about, well, what if I'm just doing work on the internet? Those arise in the employment context too. Where's the employee regularly resident? Where was the contract formed? That one can, there used to be great law about where was the contract formed, and it depended on what, you know, when you sent it and when the sailboat got here with the mail and all of that kind of stuff. And now, of course, you know, you press click, agree on, you know, some of these standard form contracts, or you email a contract to somebody in another jurisdiction. It really doesn't sort of apply in the same way, but you still see that reference in some of the case law. So basically, the kind of point there is that there are going to be laws that, even notwithstanding that you say it's a California or a Delaware or a Washington State contract, there are going to be other laws that may still apply. So don't think that you can just rely on that and say, well, no, we don't have any risk because this is a California contract. And to give you a couple of examples, there's a case called Sauerkracker. In that particular case, the Employment Standards Branch decided not to take jurisdiction, which is unusual. Usually they're all about it. They're like, yes, this is not going to happen on my watch. We're going to take jurisdiction. This particular guy, it was dealing with actually an interprovincial transfer. The guy was usually based in Alberta. Head office was in Alberta. His employment contract was signed in Alberta. It said that it was governed by Alberta law. But he came over to BC for a couple of weeks to do a project. He got fired in BC, and so he decided, he originally tried to bring his claim in Alberta, and actually Alberta said, you were doing work in BC at the time, so we're not going to take jurisdiction. And then he ended up really out of luck because the BC Employment Standards Branch said, no, you were only here for 2 weeks. Every other factor points to Alberta. In this particular case, we're not going to take jurisdiction. And then another case, a sort of classic one that is cited quite a bit, called Can Achieve. And in that case, we had a resident, she was a Canadian citizen. She was trained in BC for 2 weeks by a Canadian company. Then she was sent to China. She lived in China, worked in China, was paid in China, never had any connection with BC after that 2 weeks of training, aside from the fact that she did the 2 weeks of training and she was first hired by the BC company. And that contract, they took jurisdiction over that, and Employment Standards Branch said, no, notwithstanding where you perform the work, this has enough of a connection to BC, we're going to take jurisdiction. And so they had to comply with all of the BC employment standards laws. So just to kind of specify, the other thing you've got to think about, so that's choice of law. So choice of law basically governs, that's what kind of law do the parties want to use to determine things like, was this contract formed properly? Is there a binding agreement? Was it performed properly? What kind of damages flow because of a breach of the agreement? Those kinds of questions are the questions that will get dealt with by the choice of law clause. But you got to go one step further, because just because you have that, choice of law, we're going to be governed by California law, doesn't mean that California is the only place you can litigate. So you could end up with a forum that says, okay, even though if there's any kind of connection to BC, we're still going to take jurisdiction. We might have to apply California law, in which case we're going to, as the BC court, we're going to have to bring in a bunch of experts to tell us what the law of California is. So it's still governed by California law, but you're stuck in a BC court, which you may or may not want to be. So sort of key point, choice of law and choice of forum are not the same thing. The choice of forum basically indicates where do the parties want to litigate their dispute or deal with their dispute if there's a problem. And you'll see this, this is the kind of language that in your contract that will say things like, the parties agree to adjourn to the exclusive jurisdiction of X court. And then hopefully, if you're lucky, the courts will look at that and go, okay, no, clearly everybody agreed this is where it's supposed to be, and they'll respect that contract. Now, under the Toward Jurisdiction Proceedings Act, here in British Columbia at least, that's not a guaranteed that you're going to get to keep everything in BC if that's your goal, but it will give you, you'll be off to the running start if you've at least addressed it and the parties have turned their minds to that before that they've entered into their contract. Are there any questions on those points? Or? Yeah.
Any issues about mandatory arbitration clauses, which my understanding are very popular in the States? Like, are those even acceptable, like employment contracts? Are those even acceptable under Canadian principles?
Yeah, you can definitely have arbitration type clauses in British Columbia, and how those sort of will get interpreted will, they'll look at, is this a Delaware contract? Do we have to apply Delaware law to figure out whether this is a valid arbitration clause? Are there any policy reasons that the BC court might try to interfere with that? So
arbitration takes me very fast. I think it's the impression Canada was quite happy with arbitrating everything.
Right. I think that's probably correct. And my sense is, certainly in British Columbia, at least from an employment litigation perspective, it's so expensive to litigate anything anyway that generally speaking, counsel, legal counsel, everybody knows the game. If you just take it to court or the Employment Standards Tribunal or the Human Rights Tribunal, if you put it in the hands of an arbitrator, then the lawyers probably don't necessarily know what's going on, which may be fine, but then you've got to look at, okay, who's going to be the arbitrator, and then the parties can have to kind of deal with it on their own. And then you can get into issues later about, well, is this arbitration completely final? Is there any kind of way for judicial review? So I think generally people just think it's kind of easier. We often don't have to go to court anyway, so the advantages of arbitration in terms of being cheaper and faster, as a practical matter, some of those advantages aren't really that different from the court process from an on-the-ground point of view.
I believe you've got a question.
Oh, I have a question. All right. Oh, how do I? All right, we have a question on the webinar. I'm just looking for the little machine here. Okay. This is our question. Oh, uh-oh, Katie. Can you find it? We've just lost the question panel. Don't worry, webinar audience. We'll find you again soon. There we go. Okay. How do we find that? Just that one. All right, okay, so the question is, in the Russian example, would the employee's earnings be subject to CPP, EI, and WCB withholdings? And that's a very good question. In that particular case, they're definitely going to have an issue there, and it's going to depend on insurable earnings. They don't have an employer presence, but they're paying him here. It's
typically if you have, if the employee is covered by employment insurance in their home country, then they will be exempt from EI.
Great. So there's someone in the audience who has more experience with the specific tax aspects of that, who has advised that generally if the employee would be covered in their home country, the earnings then are not subject to CPP, EI, and WCB. So that will involve the...
I'm not sure about WCB.
Oh, okay. For EI and... Yeah.
WCB, I would probably say from the WCB perspective, the same would apply.
Yeah. Well, and WCB is premiums for work done. Usually the jurisdiction is in Canada. So I think WCB there would be a different analysis than the CPP and EI.
CPP and EI,
so
that they're covered by Social Security scheme or similar plan in their home country. Again, EI, same thing, they're covered by employment standards in their own country.
So I think the short answer is EI and CPP probably not. WCB, if there's probably not as well, but for different reasons. Good question. So the three kind of takeaways, just to kind of summarize that sort of, our high-level talk here. As soon as you ask somebody to do work in another jurisdiction, you have a whole kettle of fish that you need to think about. It doesn't mean it can't be done, but you'll be in a much better position if you think about it to a significant extent before you send the person to do that other work. It's really, really easy to just walk across or do work over the internet, but if you don't think about these things in advance, you can get stung. There's a whole legal regime kind of hiding behind there. Use your pre-hire advertising, use your employment contract to kind of flush out these issues and make sure everybody's on the same page before they're actually in place doing the work. And just remember that just because you say it's a state of Delaware contract doesn't mean that every other jurisdiction is going to agree with that. So make sure you know what laws could be applied and how those might impact your business should you end up on the wrong side of somebody who really, really wants to hear that case.
Have you seen issues with U.S. companies hiring, say, Canadian residents, Canadian citizen employees who work from home, whereby they're on a U.S.-based contract? Kind of what is your experience with those situations, and where have you seen them sort of go offside?
The question is, have we seen cases where a U.S. employer has hired a Canadian citizen who may be doing work sort of from home or in Canada for that U.S. entity, and have we seen that happen, and have we seen it gone offside? The short answer is yes, we have seen it happen. Sometimes it does go offside. The easiest thing from the employment perspective is if you can make that person legitimately an independent consultant of some sort, and you can justify that, then that's probably the simplest fix from the employment side. But if you really want them as an employee, then our advice is you've got some risk there. Just be aware that that risk is there, and try to point as many factors as you can to the U.S. jurisdiction. So in that case, I would say, like, literally have the person, when you want them to sign the contract, get them to fly down to San Diego and sign it in San Diego. It seems like a bit of overkill, but you want to make sure, if you've got a telephone number for them, make it a San Diego number. Sure, maybe it gets rerouted right to BC, but make it that, try to get everything to point there. Forward the mail, keep everything as connected to the jurisdiction that you want as possible to just minimize that risk.
Okay, thanks. All right, if there are no other questions that want to be raised publicly, I'm going to close the seminar, but what I am advising you is that if you wish to stay behind, all of us will be here and for the next few minutes, because we have about 15 minutes left, and we can discuss individual cases privately with you. And failing that, thank you very much for your attendance, and I hope that you gained some knowledge from this. And obviously, it's an overview, and it's really a thumbnail sketch. And if you have in-depth issues, please be mindful of Boughton Law Corporation and our various experts, and we will be able to assist you. Thank you.